Let's now talk about the concept of space. Now, do the standards of privacy differ in a public space vis-a-vis a private space? Can you seek to enforce the right to be forgotten if you have shared something in public domain already? In a digital world again, the public versus private space is an important distinction. The expectation of privacy must be first a legitimate expectation and a reasonable expectation. The legitimate expectation of privacy varies from whether the information is actually intimate or information about your private life, or is it information regarding your utterances or occurrences in a public arena. In the public arena, where voluntary information was given for, let us say, accessing justice in terms of a petition in court, one may still have the right to request for effacement and right to maintain privacy. However, no blanket orders will be issued to private entities such as intermediaries to efface information easily. In India, public interest forms a legitimate justification for certain amount of privacy rights to be toned down. No right to privacy or right to be forgotten may exist in terms of court or public records in the sphere of administration of justice, and the courts generally do not issue directions in the absence of compelling circumstances or statutory mandates in this regard. It is only under the statutory provisions that deal with the illustratively identity of women or that of children, etc., effacement from public records of personal information or information which identifies a person is permissible. For example, women who are complainants in a case of sexual abuse or harassment might want their identity protected and masked, and that is perfectly permissible as an aspect of right to be forgotten. Masking of identity of a person, even from court orders and judgments under limited circumstances and specific instances, is permissible, such as interest of women and children in sensitive cases. The Supreme Court, in the celebrated case of Justice Puttaswamy, not only enshrined the right to privacy, but recognized the fact that this right to privacy and inherent within it, in my view, a hue of the right to be forgotten, although not an absolute right, although is subject to reasonable restrictions, can be enforced. The purpose of right to privacy is not to obliterate our past or to remove information which is contrary to the interests of free speech, or which is contrary to the serving the legitimate public interest in the fact that information should be available. The right to privacy must always be balanced against the constitutionally guaranteed fundamental right to speech and the right to know, which warrant equal consideration. It is important to appreciate that information pertaining to a legal proceedings, notably criminal proceedings, is also legally possibly required to be disclosed when applying for several governmental licenses, governmental positions, tenders, or other governmental privileges and benefits. Therefore, access to such information serves a legitimate public interest or a legitimate state interest, and in those cases, the right to be forgotten or orders to efface or erase the data from public domain may not be granted. We should always remember that the right to be forgotten does not mean that all aspects of your earlier existence are to be obliterated completely, as some may still continue to have social ramifications today. If we were to recognize a similar right, it would only mean that an individual who no longer desires that his personal data should be processed, stored or maintained in public domain should be able to remove it from the system where the personal information or data is stored but no longer necessary. Such a right cannot be exercised when information or data is necessary for exercising the right of a freedom of expression or any other right which is concomitant with that data. The Orissa High Court in a recent judgment noted that there is no statute in India which provides for the right to be forgotten, or illustratively, for example, the right to get your photos effaced or erased from a social media server or a social media platform. Legal possibilities of right to be forgotten online and offline cries for widespread debate. It also cries for some amount of contouring in terms of special legislation. It is an undeniable fact that the implementation of the right to be forgotten is a thorny issue in terms of practicality and the technological nuances. In fact, it cries for a clear-cut demarcation of institutional boundaries and redressal, which may be delicate issues and which are hitherto have remained unaddressed, but require some amount of Indian jurisprudential thought.